So now we'll start with the public interest litigation. Public interest होता है क्या? ठीक है. PIL basically. So in judicial activism we talked about this ना कि there is one PIL judicial activism. Okay, so this basically originated and developed in US. Same thing. 1960 to provide for the legal representation to the previously unrepresented section of the people. In India, it was facilitated by the relaxation of the traditional rule of locus standi. According to this rule, locus standi, like if any person who has any faced any issue or any crime, so whose rights are infringed, he only can move to the court for remedies, while PIL is an exception to this traditional rule. So basically, any public spirited citizen or a social organization can move to the court for the enforcement of rights of any such person or group who are poor or ignored or social economically disadvantaged to approach the court for remedies. They can also go on their behalf, right? So it is necessary for the maintenance of the rule of law, because at least someone needs to take stand for someone who is underprivileged, right? So basically it gives us the vindication of the rule of law, the justification of the rule of law, facilitate the effective access to justice to the socially and economically weaker section of society. The meaningful realization of the fundamental rights comes from the PIL. Features of PIL: it is a strategic arm of the legal aid movement and is intended to bring justice within the reach of poor masses who actually constitute the law visibility area of humanity. Yes, intended to promote the public interest, not like to prove something wrong is done to someone and he's no court to ask punishment for the one who did wrong. Exactly, like so anyone can come on their behalf, not like to prove something done to someone. Yes, it demands that violation of constitutional legal rights of large number of people who are poor, they should not go unnoticed. Litigation is taken for purpose of redressing public injury, enforcing public duty, protecting the social collective diffused right, and interest on vindicating or justifying the public interest, right? The role held by court is more assertive than in traditional actions, and unlike traditional dispute resolution mechanism, there is no determination or adjudication of individual rights, because people will come with a case which involves a lot of people, like a lot of people face the same issue. Let's say Dalit. There are slaves, mazdoor, who work in a very remote area of India, right? And they are forced to work. If I go there and file a PIL, right? File a PIL, so I will represent all of them, right? So it's not like this is the public interest of all those people, not the individual interest. So that is the scope of PIL. In 1998, the Supreme Court formulated a set of guidelines. तो कुछ guidelines बताए होंगे 2003 में. कुछ मैटर्स तो 2003 में जो बताया था. पहला था बॉन्डेड लेबर मैटर्स, द चिल्ड्रन अब्यूज मैटर्स, वुमेन हरासमेंट मैटर्स, कस्टोडियल इश्यूज लाइक इम्प्रॉपर फूड, बीटिंग इन जेल, पिटिशन अगेंस्ट पुलिस रजिस्टरिंग अ केस, वो केस हो सकते हैं, पिटिशन अगेंस्ट को विलेजर्स और पुलिस फॉर टॉर्चरिंग द SC/ST, दलित बोला मैंने अभी, पिटिशन फ्रॉम द रायट विक्टिम्स, दंगे फसाद हुआ, कोई मार वार खा गया, कोई ग्रुप पूरा, पिटिशन पर्टेनिंग टू एनवायरमेंट पोल्यूशन, ड्रग्स, फूड एडल्ट्रेशन, फूड पॉइजनिंग हुई किसी को तो उस केसेस में, फैमिली पेंशन, इन सब केसेस में आ सकते हैं. केसेस विच विल नॉट बी entertained in the PIL: land law, tenant matters, service matters and those pertaining to pensions and the gratuity, वो केस नहीं आ सकते. Complaints against the central and state government departments and local bodies except for mentioned in the 1 to 9. मतलब ऐसा जो नॉर्मल वाले केस थे, किसी इंडिविजुअल केस है तो वो लेके जाओ अपना कोर्ट्स में जाओ. PIL you can do that, right? Petition for early hearing of cases pending in High Court and Supreme Court. So it's this kind of PIL which is against the courts only. कि भैया इतना टाइम क्यों लग रहा है जजमेंट देने में, राइट? दैट इज इट. Now coming to the principles of PIL. So court in exercising powers under Article 32 and 226 writ वाले केस में can entertain a petition filed by any person in the welfare of people who are in disadvantageous position and thus not able to knock the door of court. So आ सकते हैं, ठीक है. किसी कोई पिटीशन फाइल कर सकते हैं उन रिट जिनके लिए किसी फंडामेंटल राइट ब्रीच हुआ है, तो वो जरूरी नहीं कि वही पर्सन है, कोई भी आ सकता है. An issue of public importance, enforcement of fundamental right for a large number of people, a court writ, even a letter or telegram is PIL. Okay. Common rule of local standards relax for this. Whenever injustice is meted out to a large number of people, court will not hesitate to step into invoke Article 14 and 21 of Constitution of India, as well as the international conventions of human rights, which provide a reasonable and fair trial. जब उनको लगा कोर्ट को जब ऐसा लगेगा, राइट, देन when court is prima facie, जब कोर्ट सामने से देखता है, लेट्स से कोई जस्टिस देखा, satisfied about the violation of any constitutional right of any group, then it has no question regarding maintainability of petition. Then I think they can suo motu, like without even PIL, like I will file the PIL myself. Dispute between two warring groups not allowed in PIL. Even if some person went to High Court or other court for his personal grievance, after the appropriate case is PIL, then also court can take that PIL for पब्लिक इंटरेस्ट. मतलब PIL फाइल करने के बाद कोई उधर चला गया हाई कोर्ट, उसके बाद ही PIL मानेंगे उसको. Court in special situations may appoint commission or other bodies to investigate into allegation and actually find out facts. Okay. Ordinarily, High Court should not entertain a writ petition by way of PIL questioning constitutionality or validity of a statutory rule. So basically, High Court should not entertain any PIL जो किसी law की constitutionality पे सवाल उठा रहा है, पूछ रहा हूँ, writ petition. Okay. Court would ordinarily not step out of the known areas of judicial review. मतलब उससे ऊपर नहीं, बेसिक स्ट्रक्चर वाला उतना फॉलो करो, उसके ऊपर बढ़ के नहीं दे सकते. रिट पिटीशन बाय वे ऑफ PIL 226 आर्टिकल के अंदर क्वेश्चनिंग कॉन्स्टिट्यूशन, ठीक है, वो उसके लिए PIL है, उसके लिए आप केस करो सीधा. High Court, although may pass the order for doing complete justice to parties, although it does not have a power akin to Article 142 of Constitution of India, SCS power. Okay. मतलब कंप्लीट जस्टिस टू पार्टीज देने का वादा कर सकते हैं, पर उनको एक्चुअली सुप्रीम कोर्ट का इतना पावर नहीं होता है जो उसको 142 आर्टिकल से मिलता होगा. ओके. गाइडलाइंस फॉर द एडमिटिंग ऑफ PIL. Court must encourage genuine and bona fide PIL and effectively curb and discourage PIL for which are like not genuine. Instead of every judge devising his own procedure for dealing with PIL, SC formulate rules करें genuine bona fide PIL. First, if court sees any prima facie verify the credits of petitioner before entertaining the PIL. If court should be prima facie against satisfied with the contents of the PIL, okay. If court should be satisfied that substantive public interest is involved in the PIL, okay. Court to make sure that petition which involve larger public interest and gravity has some gravity that should be prioritized, okay. Court should ensure that there is no personal gain, प्राइवेट मोटिव और ऑब्लिक मोटिव बिहाइंड दैट पर्टिकुलर PIL. जैसे किसी को गवर्नमेंट को गुस्सा निकालना तो उसने PIL फाइल कर दिया, राइट. तो उस केस में कोर्ट वो सब चीज़ें कोर्ट को पहले से PIL एक्सेप्ट करने से पहले सब चीज़ें देखनी पड़ेंगी. कोर्ट शुड ऑल्सो इंश्योर दैट पिटीशन फाइल बाय फॉर एक्सट्रानियस और अल्टीरियर सीक्रेट मोटिव्स निकलवाने के लिए दे मस्ट बी डिस्करेज्ड. सो आई थिंक कोर्ट कुछ कॉस्ट तो होता है PIL फाइल करने का, इतना नहीं होता बट कुछ तो कॉस्ट होता है. So busy bodies who takes interest in others. Exactly. मतलब कोई बॉडी है जिसको दूसरे की ज़िंदगी से मज़ा नहीं आ रहा था, उसने उसके खिलाफ कोई PIL डाल दिया, बोल दे पब्लिक इंटरेस्ट का केस ऐसे डाल दिया, समझ लो. तो these motives should be discouraged by imposing some cost on that. Irrelevant PIL द्वारा उनको थोड़ा सा एडमिट नहीं करना चाहिए. This was about the PIL system in India. समझ रहे हो ना. तो एक कब से चालू हुआ था, 1960 तो US में आया था, फिर इंडिया में धीरे धीरे करके आया. 2003 में बेसिकली कौन सी कैटेगरीज है वो सब डिसाइड किया गया था. फिर 1998 में सुप्रीम कोर्ट फॉर्मुलेट किया था PIL का. आई थिंक भगवती दास करके कोई थी इंडिया में, कौन थी यार, चीफ जस्टिस भगवती कुछ करके थे, कहीं मैंने न्यूज़ में पढ़ा था. So that is something. So thank you guys.